First, I wanted to apologize. Apparently, there was some scheduling mishap on our website. We had a last-minute scheduling change for the healthcare debate, and it was not reflected on the website. And so some people came at 2:30, and that's clearly an issue on our end, so we apologize. If those excess drink tickets that I mentioned earlier are any consolation, they're yours. So come find me again at the reception. We now begin.
Comparative justice, right?
We now begin our final panel, and I'd like to introduce the moderator, though he needs no introduction because he was here last night to give some remarks. But for good measure, Dean Kramer joined Stanford Law School in 2004 as the Richard E. Lang Professor of Law and Dean. He has written and taught in constitutional law, conflicts of law, civil procedure, federalism, and the role of courts in society. After law school, Dean Kramer clerked for Judge Henry Friendly of the U.S. Court of Appeals for the Second Circuit, and then Justice William Brennan of the United States Supreme Court. And Dean Kramer has been instructed, or I'm at least instructing him now, that we are ending at 5:45 sharp. So if you have a question and it's approaching, just know that we probably won't get to you. So thank you.
So welcome, everybody, and I believe this is the last panel of the day, and of course, for those of us who live here, the most important one, the only one that really counts. So here we are in Silicon Valley, which is, of course, the center of, what is or will, I suspect, be looked at as the revolution equivalent to the Industrial Revolution or any number of other major shifts in the way in which people live and conduct businesses over time. I will just one quick story I have to slip in just in my sense of this. We were actually trying to recruit somebody at one point from a law school out in the East, in the Boston area. And I said to the person who works in this area that of course you should come here because this is the center of the universe for everything that you care about, and there's so many important things that are happening. It's not that nothing is happening anywhere else, but to not come here is sort of like staying in some small town in Scotland instead of going to Manchester or London during the Industrial Revolution. Or, the American Revolution happens, and the states have always been the center of authority, so you have to make a decision. Do you stay in Boston, or do you go to the new capital and join the new government? And if you are farsighted, you go to the new capital and join the government, and you become John Adams and are a major historical figure, well remembered 250 years later. And if you're Sam Adams, you choose to stay in Boston and you become a beer. So, of course, what goes on here is, and what goes on with respect to the regulatory state is a matter of enormous concern here. That is to say, what government does or can do that will either enhance or impede the growth of technological innovation and invention is obviously something hugely important, and that's what the panel here will discuss. I'm going to just quickly introduce everybody and then just pose a question and give everybody about 10 minutes to talk about it, and then they'll talk a little bit, and then we'll turn it over to you. So I'm going to do this in alphabetical order. So we'll start with Richard Epstein, who also hardly needs an introduction. Richard is a pivotal figure in the legal academy and scholarship of at least the past half century. He wasn't in it for all of it, but of it, he has certainly been one of the most important. He's a major scholar in too many fields to list, but it includes torts, constitutional law, administrative law, law and economics, property, and many, many more. He's also, I should say, speaking as someone who was his student, a great teacher and mentor. Just quickly, by way of background, he earned his bachelor's from Columbia in '64, then got a bachelor's in jurisprudence from Oxford in '66, and an LLB from Yale in '68. He did very well in law school, did not get a Supreme Court clerkship, according to the story he told us when he interviewed for the clerkship with Chief Justice Warren. He was asked which of the chief's opinions he didn't agree with, and he said, well, where should I begin? Not calculated to get a clerkship. Instead, then he began teaching at USC, where he taught from '68 to '72. He then moved to the University of Chicago, where he was from 1972 until 2009. He is now at NYU. Richard is also one of the rare academics who made the transition to becoming a public intellectual, but did so without giving up either his deeper scholarly work or his reputation among people who value deeper scholarly work. And his versatility, of course, or maybe I should just say gumption, is shown by his being on this panel, as well as several others. Next, Tony Falzone, who is to my immediate left. my immediate left, your right for me, is the executive director of the Fair Use Project and a lecturer in law here at Stanford Law School. The Fair Use Project is a project that we started about 6 years ago that is designed to both clarify and expand the boundaries of fair use in copyright. Tony came with a really strong background to do this sort of work. He was a 97 graduate of the Harvard Law School, clerked for Barry Moskowitz in the Southern District of California, and then joined Bingham & Cutchin, where he litigated IP cases before coming to Stanford Law School in 2007. While directing the Fair Use Project, he has won a number of important cases against the likes of the Joyce estate and Yoko Ono. And on that one, for those of us who are like deep Beatles fans, it doesn't matter what side we were taking as long as he beat Yoko. Someday I'll show you all the press release that I wanted to put out that nobody would let me. He argued, unfortunately with less success, the Golan case in the Supreme Court this year. Tony has repeatedly been recognized as one of the top lawyers and one of the top IP lawyers in both California and the country. Next, Mark Lemley, who's at the far end of the table. Mark is the William H. Newcomb Professor of Law at Stanford Law School and also the director of the Stanford Program in Law, Science, and Technology. Mark earned his BA here at Stanford in '88, followed by a JD from Bolt in '91. He clerked for Dorothy Nelson on the Ninth Circuit, spent several years in practice before joining the faculty at Texas in '94, where he stayed until 2000. He moved to Bolt in 2000 and then to Stanford in 2005. It's actually difficult to introduce Mark in brief. His is the only one, even trying to make it brief, it actually spilled over to the other side of the card. There is no question that he is the leading academic in the field of patents, but he may also be the leading practitioner in the field as well. He is positively Posnerian in his capacity to get things done. So while publishing 7 books and a 2-volume treatise and 122 full articles, he's also a founding partner of Dury Tangri and maintains a healthy practice, having argued countless cases in both district courts, courts of appeals. The list of awards that Mark has earned over the years is actually, in fact, like too long to read. So what I wrote is just think of every award that's given to lawyers that you might want someday to earn, and Mark has received it, a number of them on multiple occasions. Then at the far end here is Peter Thiel, also probably needs no introduction. Formally, Peter is the head of Clarium Capital, which is a hedge fund, but as I suspect most of you know, much, much more. Peter earned both his BA and JD from Stanford, the latter in 1992. He is an original in all respects. As a kid, he was one of the highest ranked chess players in the United States, although I gather Gene Mayer can give him a run for his money. While he was at Stanford, he founded the Stanford Review at a time when there was little by way of an outlet for conservative or libertarian voices for students. After law school, he clerked for Judge Edmondson on the 11th Circuit, spent a short time at Credit Suisse, but then co-founded PayPal. The rest is well known. Peter created a place for himself as an innovative hedge fund manager and a venture capitalist with an astonishing eye for successful ventures, including, most famously and now in film, Facebook. He also created a place for himself as a public intellectual and provocateur, and is also well known for his support of such things as the Singularity Institute on Artificial Intelligence, the Seasetting Institute, which creates autonomous libertarian communities, and most recently the Thiel Fellowship for Young Entrepreneurs, which is for young people who may be better served not going to college than doing so. He teaches an occasional class at the law school. Actually, he teaches at the law school as often as I can persuade him to take the time to do so. And the way I conceptualize that class is basically it's the world according to Peter Thiel, and I don't actually care what he does. Seriously, the idea is if you have a law school and you can put extraordinary minds in front of people and just give them the chance to interact, that's a good thing for them, and that's why we try to get Peter to teach as often as we can. Lastly, and speaking of people who are at the heart of the ongoing technology and information revolution, is Ted Ulyat to my immediate right, who is the Vice President, General Counsel, and Secretary of Facebook. He earned his BA from Harvard in 1990, followed by a year in France, and then a JD from the University of Chicago in 1994. Ted then clerked for Judge Michael Ludig in the Fourth Circuit and for Justice Scalia on the Supreme Court. After his clerkship, he was a lawyer at Kirkland & Ellis, although he moved to AOL Time Warner in 2001 as Associate General Counsel, and then from there became the General Counsel of AOL Time Warner Europe, I suppose making use of that French. He joined the Bush administration in 2008, first in the White House and then as Chief of Staff to Attorney General Gonzalez. Returned to Kirkland following the end of the administration and joined Facebook in 2008, where he currently is. So with that, let me open this up. And as I say, I'm just going to pose a question that gives everybody a chance to talk a little bit about the issues that we're dealing with here. And I think we'll, again, start alphabetically, which means I will start with you, Richard, and count on you to set that tone of 10 minutes exactly and no more. So really, we'll get people just to reflect a little on, what is the relationship between technology and the regulatory state, and how, if at all, should government regulate technological progress, innovation, and all the good things that we hope to get out of technology while hopefully limiting the bad.
All right, well, thank you very much for giving me the first chance to do this. And what I will do is I will start the carp with the question and then try to give an answer to the question slightly reframed. There is certainly a very powerful question about figuring out the relationship of technology to regulation, but there are many regulations that one can think of which do not get you involved with the so-called regulatory state. And so the question then is exactly what kinds of regulations are desirable, and why is it that I think that they don't fall within this larger category of regulations which are generally dubious? Well, the first point is every system of law needs a system of regulation. Even in purely competitive markets, you have to establish a system of property rights. You need systems of recordations. You need a statute of frauds in order to make this thing go, and you have to have taxes and so forth to support it. So the thought that there is some disembodied free market out there which doesn't depend upon government force is, if not an anarchist myth, it's certainly mistaken. But the key features under these circumstances is what is the point of the system of regulation. And what it's designed to do in virtually all these cases is to fortify, by reverse engineering, a system of competitive markets. So strong property rights protected by regulation, statute of frauds on formalities of contract, prevention against inducement to breach of contract, and the use of force against contracting parties all drive you very much in that kind of a position. And I don't think that there's anybody who can quarrel with the fact of regulation in these kinds of areas or treat it as a sign of regulation in a regulatory state. Now, what happens is when we come to technology, there are two important fields that I'm going to discuss, and each of them requires at least some deviation or at least some modification of the earlier positions. And the two types of systems that you're going to refer to are, in fact, the intellectual property system, which for these purposes is copyrights and patents and trade markets and trade secrets and so forth. And the other turns out to be the network industries having to do with railroads, telecommunications, and so on. And the issue is what makes these things special, what's going to be the kinds of regulations that we ought to welcome, and what are the kinds of regulation which are part of the regulatory state that we ought to be very concerned about. So let's turn to the first of these things with the Intellectual Property Act. And what is so clear about intellectual property is that it is not simply enough to allow people to take first possession physically of property and announce that they own it. So as early as 1790, I guess it is, we start off with the Patent Act and we start off with the Copyright Act. And the question is what makes these statutes, at least in large measure, the kind of long-term success about it? Well, the first thing about it is that neither of these are meant to be technologically forcing within their respective domain. So with respect to the patent statute, what the law does is it gives you a system whereby if you file first or invent first, there's a battle as to which of these two things actually matters. Then there will be an examiner who will decide whether or not this particular patent is or is not going to be valid. And if it's protected, what happens is then it falls into the sphere of ordinary property rights, protected, it used to be at least, by injunctions and damages in the event of infringement, which is the intellectual analog towards the ordinary torts of trespass, and which allows you the ability to sell it, to license this thing, which is, of course, the power of disposition associated with these kinds of rights. And by virtue of the fact that you have yourself a decentralized system in which anyone can start to play the game, the only real questions that you want to have with respect to this system is just how it is that you make it as efficacious as possible. And in dealing with this thing, I think the 1952 Patent Act Act, which was the act before this godforsaken American Invents Act of this past year, did a pretty good job in trying to figure out what kinds of advances, what kinds of subject matters were eligible for patent protections, what level of advance over previous things you needed in order to get that protection, and so on down the line. There were certainly controversial features about this system, and the eBay case, which weakened the injunctive reliefs question, and some of these cases having to do with LG, which limited your ability to create various kinds of licenses, I think in general were sorts of negatives with respect to its operation. The thing that one most fears with respect to property rights under the patent system is that there will be a variety of mistakes. One of them is you could lengthen their terms unduly, which is a real problem that I think Mark is going to talk about in connection with copyrights, and Ted, which I'm certainly opposed to. I don't think that's a real risk in these particular cases, but you could make the system completely sort of convoluted and so forth that you no longer understand its actual boundaries. This would include having elaborate and complicated re-examination provisions, most of which strike me as a huge mistake. And it also requires the fragmentation of patents so that business method patents, for example, start to get very special treatment. I think the simplicity and the robustness of the older system were in fact correct. On copyrights, again, you need to have some system of registration, but there you don't need a system of examination, and the two systems, of course, have widely parted grounds on that. The question of durability of intellectual property under the copyright system is subject to genuine tension because copyright patents for software are generally short-lived things, and for Shakespearean sonnets they need to be longer. But you should be very cautious about gratuitous extensions of the length of the patent, so that things like the Patent Term Extension Act is, in my mind, a kind of mistake. And I think for the most part, we've tried to keep relatively to the privatized model here. And the more we can basically analogize the traditional forms of property, the better we will be. When you swing over to the other side of the line with respect to the question of how you deal with technology under network industries, again, for a whole variety of reasons, it has always been the dominant and correct position that when you're dealing with institutions that have monopoly elements and cannot form truly competitive types of situations, that you must have some system of government regulation. And the question is, what form of system is going to be appropriate? And in this particular situation, the choice of methods can make a huge difference. I'm just going to give one example of a kind of regulation which came a little bit too soon and created trillions of dollars in losses because it managed to get the wrong solution. And I'm thinking of the 1996 Telecommunications Act, because to the extent that you're trying to figure out how you run one of these systems, if your fundamental postulate is that the local exchange carriers will remain forever, have monopoly power, which means that you have to be very complicated in the way in which you introduce new entities and allow one company to buy network elements from another, you've managed to capture the elements of the essential technology in 1996, but by 1998 it was quite clear that the implicit assumption of that act, the dominance of the exclusive power of the local exchange carriers, were wrong. And when you started to allow the government to force the sale of particular network elements at bargain prices, you created all sorts of distortions in that market, which in the end helped nobody. So the great question that you have to worry about when you're dealing with this market is exactly the question, what's the form of regulation that you want? And in that case, the mistake was, instead of having the government supervise interconnection agreements, which could have been done relatively easy, they went to this system of forced exchanges that dominated. We're now in a new age, and what happens in this new particular age is with the decline of the local monopolies under these exchange carriers, what you end up with is a system in which entry now becomes a really plausible type of arrangement. That is, instead of trying to force people to interconnect, you could let people build out other kinds of networks, and in the course of using those particular networks, enter into competition one to another, where in many cases there may be some need for interconnection, but in many cases there will not be, as for example with a lot of these networks which are designed to transmit huge amounts of data and so forth. And so the question is, what's the appropriate system of regulation? And I think the fundamental postulate that you would want to adopt in cases of this sort runs as follows. If you could conceive of a way in which new technology allows for the facility and the creation of competitive networks, you want to treat this no longer as a monopolistic industry with a single supplier in a single place. What you want to do is to treat it as a competitive industry and let these people determine the composition of the traffic that they take over their networks and, in effect, the prices prices that they're going to pay for the traffic in question. This means, in effect, that if these alternative networks are available, the last thing that you want to do is to impose any kind of network neutrality requirement on these systems, because that becomes a very funny kind of wealth transfer from those people who put the pipes together to those people who want to push content over it. Well, one of the things we can say about a net neutrality system is that the value of the information is relatively homogeneous and the cost of providing it is relatively low. There isn't much to be lost by having a pro rata system, and in fact, in many cases, that's what firms will do if it turns out that it isn't worth their while to try to engage in any forms of discrimination. But as we've seen the other day from the AT&T announcement that it was throwing in the towel and it was going to start to put limitations on the maximum amount that any given customer could throw through a network, there are serious capacity constraints even in the most capacious networks, because as they make the pipes larger, there are people who find larger things to send over the pipes. So nobody would have thought of sending hundreds of movies over the pipes in 1990, but now that you have pipes big enough to do it, the company will come. And at this particular point, the differentiation in rates seems to me to be extremely important, because what you'd like to be able to do is to give higher valued services higher prices so that the network on the other side could start to organize itself. So the difficulty that you get in running one of these things is you have to first answer the question of, is this something that looks remotely like a competitive industry? And then if it 2 or 3 carriers, I'm willing to say yes, 1 or 2 carriers, well, 1 clearly not, and so forth. And that the dominant strategy in this particular area is not to try to have heavy-handed government regulation, which sets prices and mandates entry and so forth. That will make the technology industry look like the healthcare industry that they talked about at lunch, where you have mandatory service and so forth. What you want to do is exactly the opposite, to try to find ways in which you can expand the opportunities of entry so that you could reduce the number of opportunities or needs for having direct kinds of control. And I think, in effect, that the way in which this particular choice is going to be adjudicated in the next generation is going to determine, for better or for worse, whether or not this nation, or indeed other nations, will be able to keep up the energetic drive. Every time you regulate tough stuff on the guys who are the pipes, you're going to help the content providers to some extent, but you're going to retard investments on the other side. I think voluntary arrangements are going to figure out which is the optimal way in which to structure that kind of interaction, and I think we don't want to go to the regulatory state in order to run that issue. I think I'm out of time.
Yes, I was going to say, most people you cut off mid-sentence. Richard, you have to cut off mid-paragraph, but thank you.
I was done.
That's a compliment, by the way.
Thank you. No temporal trespasses, right?
So, Tony, again, same question to you. How should the government think about regulating technological progress? Should it? What's the role?
I have a couple of general observations and a couple of specific examples. I think, number one, technology can benefit tremendously from government involvement. Regulation may be part of that involvement, but if you think about it just in terms of regulation, you obscure some important points. And when you start talking about the framework of regulation, you're automatically in this paradigm where technology is a private good, and the question becomes, well, what is the government going to do to restrict your private use of that particular technology? And what I think that obscures is the fact that technology is very often a public good. That is something that's going to be underproduced by the private market. And so to get back to the network that matters the most around here, you talk about the internet. Well, that began as a creature of government-funded research. It became a platform, this piece of infrastructure that laid the groundwork for all sorts of innovation that nobody could have possibly foreseen in the 60s and 70s when the government was funding the research that led to the internet. Nobody could have predicted the wealth it would have created or the innovation that it was going to help foster. But now, once the internet grows up, you have problems that you have to deal with, and one is network neutrality. So the question there is whether and to what extent we're going to let the people who own the infrastructure adopt practices that are going to favor or disfavor certain types of data, applications, content, or certain users. The stakes there are particularly high because that is where we decide whether the internet is going to remain an open platform where new people can innovate without permission, and whether we are still going to see the kind of radical disruption that has marked internet technology. If you let incumbents make the rules there, you're not going to get the innovation that you see when you have an open architecture that lets everybody in and lets somebody brand new come in, whether they have permission from the incumbents or not. When it comes to network neutrality and the innovation that's at stake, I ask, well, is there a good market solution there? I don't think there is. And since there's no good market solution there, I think that's a good place where the government intervenes. And its role there is really to, I guess, kind of regulate, to keep the structure open so that new entrants can come in and you have room for new innovation that is not limited by what we already see on the internet. If you take a different question that the internet poses, one of privacy, you have a different question, I think kind of a different answer. And the question there is whether you're going to regulate what information websites are going to collect and how they can use it. There I see a much bigger potential for market-based solutions. I think you can think about disclosure, you can think about competition, in whether it's in technology or the development of applications that are better or worse at protecting your privacy. There's some barriers to it. I think the information costs are very high for users. I think a lot of users don't really fully understand some of the privacy implications of data collection. I think it's difficult for them to make trade-offs and really make the balance that a market solution is going to require. But the fact is, it's at least possible to imagine some market-based solutions to privacy problems. So what do we see here? Well, with the new do not track proposal that we saw from the White House in the past few weeks, I think you see what is in some ways the worst possible of all worlds. And that is because the so-called do not track proposal you see is really much more like, well, we're going to let some people track and some other people not track. Problem being that it utterly confuses consumers. If you have regulations that ostensibly prohibit tracking but actually permit tons and tons of tracking, then I think what you end up with is you lull the consumer into a false sense of security or complacency that prevents the market solution from implementing itself. So in that respect, I think that's an example where regulation can really foul up what might otherwise be a perfectly plausible market solution. And government regulation is often at its worst when it takes on this sort of pervasive and permanent oversight function. So what I would say is if you believe technology is a public good that's going to be underproduced, there is a symbiosis between innovators and the government. But I think the right model might look something more like seed funding than permanent oversight. I think government is at its best when it cultivates technology and then gets out of the way. Now, number two is important because sometimes getting out of the way means not just the government getting out of the way, but the government playing a role to make sure that incumbents also do not stand in the way of new inventions and new innovations that is going to grow technology and develop it even further.
Thank you. So, Mark, I'm going to pull you in a slightly different direction.
I want to answer these questions. So.
You can do that too. Well, I actually, in some sense, I'm hoping I can get you to ground us a little more in particular things that have been happening, so we get a little less abstract. So, and a lot of this comes, I should say, from conversations I've had with Mark. So, you've often talked about the way in which there's been a kind of regulatory turn in IP enforcement online recently. So, SOPA, PIPA, the government has started to seize domain names. You've got government mandated or encouraged efforts to have ISPs monitor the content of their subscribers' accounts and so on. And then, of course, the whole debate over network neutrality, although slightly different, obviously reflects the same. So being a little more, what do you make of all of that? What does it tell us? Right. Can we draw some conclusions also about can we get government to regulate when we want and not regulate when we don't want? And what do we do if not?
Right. So I mean, look, I think there's a consensus, at least so far on the panel, and my guess is on the whole panel, right, that starts from the idea that historically, and certainly today, technology's flourished where market entry is free. Right? If, in fact, people are free to come up with a new idea that's completely different than anything anybody's done before, that everyone says won't work, and launch it into the marketplace, we get a lot of benefit. We get a lot, and people make a lot of money, and we change the world. And so what we don't want from government is a mother may I regulatory regime. Right? If we've got a regulatory regime that says, I need permission to get into the market, I need permission to do this new thing, then we've got a problem. Right? Because then we're now relying on the government and not the innovator to do this. And the one thing I want to add, I think, so far I think I'm aligned with Richard, but the one thing I want to add, and I think Richard would sign on to this, but it may lead us in some different directions, we also don't want a private individual who's got a mother may I control over market entry, right? It's not, the problem is not just that governments might get to decide as gatekeepers who can enter the market. The problem is also that particular incumbents can and will have an incentive to impose those restrictions if they have the ability to do so. And it's important to remember, because it quite often gets lost in the rhetoric around some of these debates, it is not the case that private decision-making is efficient. It is the case that market decision-making is generally efficient. But market decision-making is generally efficient largely because a bunch of stupid or greedy or short-sighted private people who make the wrong decisions get thrown out by other people who make the right decisions, right? So for the market, for private decision-making to work, there's got to be a market that's competitive. And if we have a mother may I regulatory regime, either government-imposed or incumbent-imposed, we're not going to get that. So get to the specifics examples of that Larry has raised. Intellectual property, I think, is hard from this perspective because you can look at intellectual property as Richard does and say, oh, it's a property regime, it's something around which parties can freely contract. Property regimes, if we're libertarians, we think are good, so more intellectual property is better. You can also look at intellectual property rights and you can say, this is a government restriction on what people can do with their own physical property and their own ideas. Government restrictions on what people can do in a marketplace are bad, and so libertarians ought to think IP rights are bad. The problem is it's both. Right? It is at once the sort of basis around which we can contract and allow the spread of new ideas, and it is a government regulatory intervention in the marketplace that is designed to restrict in certain circumstances what people can do. What I think we've seen in intellectual property, in both copyright and patent in the last few years and maybe in the last few decades, is a turn increasingly towards the regulatory side of intellectual property and away from the kind of free and open licensing. And in part you see that if you look at the statutes, right? If you look at the copyright statute as it existed in 1975, and you compare it to the copyright statute that exists today, I think it's 4 or 5 times as long. Right? There are large swaths of the copyright section that really are regulation. They regulate price, they set compulsory licenses, they determine what you can do, and so on. The Patent Act is moving in that direction. Most of the main provisions of the Patent Act have been sort of common law in their orientation. As Richard indicates, the new patent statute is definitely a step towards the regulatory piece. But I think we see it not only in the statutory frameworks, I also think we see it in the way in which the law is being applied. So in copyright law, after 15 years or so in which government more or less, sometimes by being physically restrained, kept its hands off the internet, we see greater and greater efforts pushed by copyright owners to try to impose regulations on what it is that people can do online, because the copyright owners are rightly concerned that there's a lot of copyright infringement online. Right? But rather than sue for copyright infringement, the move has been instead to say, you know what, let's decide whether or not you can put your website up at all. The government has seized and shut down in this country 450 internet domain names and all of the speech contained thereon without ever getting an adversary hearing and a court order that says there's any copyright infringement here, much less the entire site is copyright infringement. That's regulation. That's a mother may I regime, right? Suddenly you're not in business because the government has decided your website is not appropriate. We've seen efforts by the government and by private parties to push technology mandates. Your website will be permissible only if you adopt certain types of filtering technologies to strip out improper material. And in those cases, too, I think we're moving away from a regime in which people are free to put what they want on the internet and towards a regime in which we try to impose ex-ante regulation. I think we see something similar in patent law. And it's here a little bit more troubling, and here I know I'm going to disagree with Richard. Patent law is supposed to increase innovation, right? The goal of the patent system is encourage innovation by giving innovators economic rewards. It should worry us that our fastest developing, most innovative industries, the ones that are generating the most new innovations and the most money, by and large hate patents. Right? They view patents as a tax, as a cost of innovation, not as a benefit of innovation. And they view them that way, I think, largely because they are happily innovating in a world in which they are not restricted by the law. And when the law shows up, it shows up to limit what they can do, not to encourage them or help them to get economic benefits. Right? So in the information technology industries, in the software industries, where there are lots of patents and where most of the patent lawsuits are currently filed, the most innovative companies will tell you patents are largely a problem for us. Right? And the people who are filing those patent suits are either people who are not in the market at all, the so-called patent trolls, or they're the people who are on the market decline, right? They're Yahoo asserting against Facebook, as happened this week, right? Hey, here are a bunch of patents you've got a license from us. The industries which really do need patent protection, right, and the reason we need strong patent protection for certain parts of industries, the pharmaceutical industry and the biotechnology industry, need that patent protection, ironically enough, because they are regulated industries. Right? The reason we've got to have strong patents in the pharmaceutical industry is because the government says you can't launch a pharmaceutical product until 10 years of review have gone through and you've spent $900 million. And now you've got to have some way to get that $900 million back. Well, how do you get that $900 million back? We guarantee you insulation from competition for some substantial period of time so you can make back the money that we made you pay in the first place. I think that once you take that regulatory system for granted, and it might or might not be a good thing, we're then stuck with some need for a patent system like that, but it's far from ideal, right? Because it's moved us, I think, in a regulatory turn, right? It's about limiting market entry in the service of furthering government regulation. All right. The other piece of what Larry asked me, and we've heard both from Richard and Tony, is about network neutrality. And I think thinking about this Mother May I framework makes network neutrality a really hard problem. Network neutrality is a really hard problem because it is unabashedly government regulation in the service of open entry, in the service of not letting people stand as gatekeepers to prevent market entry. And I'm really on board with the goal of network neutrality, right? The internet works precisely because if you have a new idea, all you have to do is write code and put it on the network and no one can stop you from doing it. We do not want to lose that, and there are some powerful people who want to impose limits on that principle, and they are by and large incumbents in these industries, particularly in the transmission industries. That said, I'm also quite a bit nervous about the idea that the government is going to get it right if the government sets a series of rules designed to make sure that this openness continues. And so I think the sort of hard trade-off we're left with in this kind of regulatory turn in some sense is the extent to which we impose structural limitations. We keep saying, you know what, if you're in market A, you can't be vertically integrated into market B. Or impose very simple, bright line rules, even though they are inefficient at some level. You must carry all traffic, and we don't care whether you've got a good argument that network management requires you to block that traffic. You can charge different prices, but you can't discriminate against who you're charging. Because if we don't adopt those kinds of rules, those sort of structural separation rules, the alternative may be either from the government or from powerful incumbents who don't have significant market checks on them, Mother May I regime that I think we're seeing increasingly taking place.
Thanks, Mark.
All right, save it till the end.
So next we'll turn to Peter. Peter, I also want to ask you a more specific question, although, building off of what we've talked about so far, because you've spoken quite a bit and in a lot of different contexts on innovation and technology and on the death of innovation in certain industries. Clearly, and I know you agree with this, there's a lot of innovation that has happened and is still happening in the technology and computer space. And then obviously you've talked about there are other areas where innovation seems not to be happening so much anymore, transportation, agriculture, places in which there were obviously bursts of it in the past. So, the question is, why not? Is there something different about technology, or are we doing something wrong?
Yes, I think the why question is a very difficult one to answer. The why question is always hard to answer, but perhaps it is a good starting point to talk a little bit about the what. And I believe the what is that we're in a world in which we're no longer living in a technologically accelerating civilization at all. I sort of date the end of rapid technological progress to the late 60s, early 70s, and I think at that point something more or less broke in this country and in the Western world more generally that put us into a zone where there's much slower technological progress. I think there's an important exception with computers, the internet, as well as financial innovation. I think those were three areas where we had two areas, computers and finance, where we had a lot of innovation in the last 40 years. Finance is probably going to be less going forward. I'll get to that in a second. But I think it is worth reflecting on how all the other areas have slowed down, and that this is everything from transportation to energy to biotechnology, agrotech, on and on down the line. In the most literal version of the question, are we moving faster, is the transportation question. And if you think about every decade from 1500 on, people moved faster. This was a basic measure of how you determined whether society was progressing at faster sailboats, 19th century faster railroads, then faster cars, faster planes, culminated with the Concorde 1976, decommissioned 2003, and today I'd say I submit travel speeds are back to around 1960 levels when you include the very low-tech airport security systems that plague people. And it's always a good thing to point out at these sorts of conferences to get the audience a little bit on your side, since people normally have experienced it firsthand recently. The official reason for the slowdown in transportation has to do with high energy costs, and this points to a much greater failure in energy innovation. At this point, we have never recovered from the oil shocks of '73. Oil prices today are higher than they were during the Carter catastrophe of the late 70s. Clean tech has become basically a toxic word for money-losing investments in Silicon Valley. And of course, you look at all the other areas. The nuclear industry was dead already decades before Fukushima, and I think it would be almost borderline immoral to encourage any undergraduate to study nuclear engineering today as a career with much of a future. If you look at Warren Buffett, perhaps the savviest investor of our time, his single biggest holding is in the U.S. Railroad industry, which is basically a massive bet that the transportation and energy consumption patterns of the 21st century will involve a return to the 19th century. 40% of what gets transported on rail is coal, and so Buffett's basically making a bet that after oil, we will not go to clean tech, we're going to go back to coal, and we're going to go back to railroads. And I think there is a lot of reasons to think that that's the basic trend that you're on with respect to that. The crisis in energy in the last decade has broadened into a more general commodity crisis. There was a famous Simon Ehrlich bet in 1980 looking at a basket of commodities, how they would perform over a decade. Simon happened to win the bet that decade. If you reran the bet from 1993 onward on a rolling decade basis, Ehrlich's won the bet every year, and we're basically living in an increasingly Malthusian world in which there is incredible scarcity because there's not enough innovation to keep pace with things. The Green Revolution was the great agricultural revolution of the 50s and 60s, increased worldwide food production by over 100% during those decades, has massively decelerated in recent decades. And so when you see events going on in the world through this prism of technological deceleration, it gives you a very different perspective on what's going on. And so events in the Middle East, for example, where the so-called Green Revolution is often attributed to the wonderful information age that we're living in and how Twitter is helping connect the world or something like that, I think it has to be seen really as a direct result of massive technological failure. It was triggered by food prices that had risen by 50 to 100% in the previous few years, and basically it is what happens when desperate people become more hungry than scared. Biotechnology, we've had, by all rights, there should be tremendous progress in biotech. And again, we see this pattern of significant failure. There are about 1/3 as many drugs in FDA trial today as there were 15 years ago. The big pharma companies have finally started just firing all the scientists who have not been able to get things through an increasingly onerous set of regulations. And our expectations for the future in all these areas have been dramatically reduced. It would be inconceivable for the U.S. Congress to declare a war on Alzheimer's comparable to the war on cancer in 1970, even though something like 40% of the people who are age 85 have incipient stages of dementia. And I think something like this can be repeated in many different areas. If you ask people whether they believe that we're living in a technologically accelerating civilization, the straightforward answer is whether people think the next generation of Americans will be better off than the current generation, and most people no longer think that is the case. And I think that somehow forces us to call into question this narrative of incredible technological acceleration. There's been an important exception in computers and finance, and I would submit the why explanation for this sort of tale of two worlds, of a computer and financial world where there was a lot of progress and everything else where things were badly stalled, is that basically computers and finance were fairly lightly regulated in the last 40 years, and everything else was very heavily regulated. And we are living in a world in which bits are unregulated and the world of stuff is heavily regulated. And so, and when people say we need more engineers in the U.S., you have to start by acknowledging the fact that almost everybody who went into engineering did very badly the last few decades, with the exception of computer engineering. So when I was at Stanford in the 1980s, it was a very bad decision for people who went into mechanical engineering, chemical engineering, bioengineering, again, to say nothing of nuclear engineering, petroleum engineering, civil engineering, aeroastro engineering. The reason the rocket scientists went to work on Wall Street was not just because they got paid more on Wall Street, but also because they were not allowed to build rockets. And so, and supersonic planes, and so on down the line. So, I think there are sort of many different variables that might have come together. My own sense is that we have to think about the very heavy regulatory differential between these areas, and that this has been a big driver of this. That a sort of heavy environmental mentality has driven the regulation of the world of stuff, and the world of bits has progressed because it's been relatively unregulated. And so again, sort of the thought experiment I would give you is if you thought of a company like Zynga with its game Farmville, and you said, well, we have to actually take that through FDA approval before we allow them to produce the game. And we have to see whether, we have to have a phase, well, maybe we'll skip the animal trial, but let's go straight to the phase 2 and phase 3 trials, and you have to test for efficacy and safety. And so you have to test, is it actually safe for people to use? And you have to have a double-blind test with lots of different people, and then you have to have a test for efficacy. Does it actually improve your brain functioning? And if it doesn't do that, you can't do it. And if you change one line of code, you have to start all over from scratch. And you would not have a video game industry in this country, or any sort of entertainment industry, if you had that. So I think there's been sort of a catastrophic set of government policies that have basically destroyed most of technological innovation, and we see this in manifesting itself in an economy in which you have stagnant wages. Median wages have been flat since 1973, an increasingly a broken political system, which is becoming a zero-sum political system. When there is no growth, there is basically a winner for every loser, a loser for every winner, and obviously the political system finds it much harder to craft compromises where everybody comes out ahead, because there's no way to actually craft such compromise. And I think that's the basic technological understanding of what's happened. We've been in massive denial about this. I think the denial has manifested itself in a series of very destructive bubbles that were predicated on continued progress that did not quite happen. I personally think that even the idea of science as a public good is not quite accurate, and that in some important ways the government played a big role in destroying science as well. And if it had to give sort of a libertarian account of the history of science, we had some very talented scientists who did a lot of good work in the early 20th century. In the 30s and 40s, the government was able to accelerate science on a one-time basis by taking those talented scientists, giving them a lot of money, and having them produce more. Probably the single biggest thing they produced was the nuclear bomb. Again, I think it would be interesting to see what people on the left think of that as the single illustration of government-funded science. The New York Times op-ed on the day after Hiroshima in 1945 made arguments very similar to the ones about science being a public good. And I'm sort of quoting it now almost verbatim, that the people who believed that science should be a private matter and was not a public good had a lot of answering to do, because the Army, having directed scientists, had been able to give a great invention to the world, e.g. the nuclear bomb, this contribution had been made in 3 short years, whereas prima donna scientists working on their own would have taken perhaps half a century to make that sort of progress. I think the problem is that at the tail end of it, science becomes politicized, and you basically have scientists who have to fight each other to get the government money. I think that just like the idea of a philosopher king is a bit of an oxymoron, that philosophers are very different from kings, I think the idea of a scientist politician is an oxymoron. Great scientists are fundamentally different from great politicians, and when you've politicized science, you end up destroying it altogether. We have 100 times as many scientists as we did in 1920. If there's less rapid progress than there was in 1920, the productivity per scientist is perhaps less than 1% of what it was in 1920. I think that's the rough math. I believe that it would be helpful to have a very comprehensive discussion as to how we get out of this sort of a situation we find ourselves in. But I think the first step is to acknowledge that we are finding ourselves, that we've been basically in a desert for something like 40 years. And if you want to get out of the desert, you have to acknowledge that you're in one and not in some sort of enchanted forest.
So, Ted, that leaves you, I want to say it's a bad cleanup, except you're fifth. So whatever that would be. Yeah. But I actually would be curious to get, obviously your perspective as someone who is literally on the trenches of all of these questions in the most immediate sense. So let's step back again to where we started and your sort of take on government regulation and its effect on what you're trying to do with technology.
Sure, and I guess I'd start by saying I love having this guy on our board because it makes for some of the most interesting board meetings possible, as you can imagine, with some of these principles coming into play. Great to be here, by the way.
I'll try to give you some cover.
Yeah, exactly. Peter and I are in the minority in Silicon Valley generally, I think, and Facebook. In our ideological leanings. Anyway, I think I agree with Mark that I agree with a lot of what people have said, so I won't take too much time here. But I do, I will try to give a little bit of a practical reflection. I think, the question, as I saw in the program, thank you, Larry, was something along the lines of, does technological progress require regulatory guidance? I'm with Peter on this. I think emphatically not, other than, as Richard kicked it off with, a basic rule of law. I mean, the rule of law, property rights, basic rule of law. I think apart from that, we get into problems when government, whether through legislation or regulation, tries to go beyond some of the basic principles and apply, I think, industry-specific and sector-specific rules. I think, for example, tort suits, contract disputes are fine. Those are the the issues that we can deal with all the time. Antitrust, that regime is broadly applicable to many, many industries and can solve, I think, for example, a problem like net neutrality without resort to a whole new framework of laws governing certain types of pipes and certain types of alleged natural monopolies or unnatural monopolies or private mother may I situations, as I think Mark was saying. So I think that's the main problem when you get legislation and regulation that tries to go that next step and tries to get too specific. I think if the question is, does technological progress require regulatory guidance? No, but I think from a company's perspective, and not just Facebook, but everybody in the Valley, and really thinking back to our careers, at Sullivan and Cromwell and at Kirkland, working on some of the Telecom Act stuff back in the mid-90s. I think the reality, of course, is that companies must deal with the reality in America today and in the world today of a robust regulatory state and a robust regulatory framework. That's the reality, and so we can talk about this. So, on the practical level, I think I would be with Peter, of course, urging extreme caution among regulators in the computer and tech and internet sector today. A few things in particular come to mind on that I think are real challenges for regulators and real reasons why I think resorting to general principles of law and long-standing legal frameworks, again, antitrust being the example, is the better way to approach these problems. One is the slow pace of regulation. Peter alluded to this with the Zynga Farmville example, the hypothetical that is. There's also the complexity of technology, and specifically of software these days. You think about, I actually did work for a while at AOL Time Warner back in the day, and you think about the way AOL used to ship product, and Peter can talk about this as well, given his prior background, but there are more discrete shipments. Today there are code pushes literally every day. We push code every single day. There are new lines of code written every single day at Facebook. There are new products rolled out and subtle changes to products rolled out constantly, and it's very hard for some people in different parts of the company to fully understand what exactly is going on with a product. Most of this is irrelevant to, it's just background, it's irrelevant to users, but it affects how things work, how the product actually works. You have to be very in the weeds to understand this, have to be very in the weeds at the company to understand this. It's very difficult, almost impossible for regulators to get a good grasp on this. And I think that's different even than 10 years ago, given in software, given the constant code push that you see today, and that style of just pushing code, having engineers working on it constantly, and adopting an attitude of, hey, let's push it out there and let's just keep refining it, keep making it better and better, instead of just waiting in the old AOL style to ship an AOL 3.2 disk. And you'd have everybody sort of working together toward that deadline of March 10th to ship the AOL 3.2 disk. So the complexity and ever-changing nature today is, I think, is a reason for even more caution than normal. There's also, of course, unintended consequences. My favorite example of this in our world is the VPPA, the Video Privacy Protection Act, this late 80s statute that's now, that Reed Hastings at Netflix is now pushing, and we support this, of getting a change to this law in Congress. But this is a statute, some of you may be familiar with it, but it was enacted in the late 80s in the wake of the Bork hearings, of all things, when Judge Bork was nominated, some enterprising reporter from an independent paper in D.C. went to his local video shop hoping to find some interesting rentals on his. So he paid the clerk $5 to get Bob Bork's rental history, hoping to find something salacious, and of course he did not. I think Patton was probably on there, Guns of Navarone, plenty of things like this. But Congress was scared of this and said, let's make this illegal, and let's make it illegal for a video provider to give records of consumer rental or purchases to publicize those, unless you get advanced consent from the user prior to every disclosure. Okay, today, move forward 25 years, 23 years to today, no one's going to video stores. Sorry, and Reed Hastings had a you know, he even had that recognition that nobody's even getting DVDs coming to their house anymore. People are getting this streaming, and people like to do things, for example, on Facebook and Netflix, such as, you know, learning what their friends are renting on the site. So if Larry goes on and says, I want to rent films from Netflix and tell my friends what I'm watching because I think these are great, I think it'd be fine. But if you want to do that,
a lot of slasher
the
films.
problem is we and Blockbuster have been hit, and Netflix has also been hit with class action lawsuits under the VPPA, essentially that is absolutely obsolete. But they're saying, well, even if a user clicks, yes, I want to participate in this program, that's technically a violation of the VPPA because it's not at the time of, it's not every single time. So this is a classic, my favorite example in our sector of how quickly a law that's targeted at that kind of specific problem can become obsolete and frustrate new development. I mean, this should be a great way. This would help the studios. This, I think, would help the studios market their films, gain traction with their films, get excitement going about their films. And you have the statute that's scaring people because you have the threat of massive damages, the statutory damages. That's an example of the unintended consequences. Also, regulatory capture, I think, is another problem, obviously, with the regulatory state today, more so than years ago. I understand that regulatory capture and regulatory arbitrage has been around for forever, but I think it's more sophisticated today. I mean, every company now has, including Facebook, we have far fewer than most other companies of our size, but we have plenty of people in DC, and so do all other companies, because you're trying to defend yourself against legislation that your competitor might be pushing, or regulations that your competitor is pushing, or bad stories, or bad memes on the Hill that your opponents are pushing. So all those are reasons that sort of shortcomings of the regulatory state and things to be careful of today, particularly in our sector. I would strongly support what Tony said about, I think, in the privacy realm, market-based solutions are available more so than in others today. I think you see in our sector alone, in social networking, plenty of people have come after us and have tried to position themselves as great alternatives to us on a privacy ground. I mean, so there are market solutions, people expressing marketing a new social network on the basis that it provides better privacy protection. That's great. We welcome that, and I think that's the right solution to that. And I think that's another thing. Social networks and also just the advance of technology generally have made consumers much more able, I believe, to protect their interests on things like privacy today. Consumers are able to criticize, organize, complain, and ultimately punish companies for actual problems or actual bad experiences rather than theoretically bad experience. If there's an actually bad experience, Path had this thing the other day, that can be publicized and be out there on all the blogs, even to the mainstream press, within hours, within a day. And then you'll have the CEO apologizing and changing course very quickly, far faster than any agency in Washington could do this, and far more effectively. I see Judge Kavanaugh and Judge Griffith here, so another point I'd make is critical to any regulatory state is an effective system of judicial review. I do think that's something that it's interesting to me thinking about. I think that's important, and the D.C. Circuit is fantastic, of course. But it's interesting to me to see the difference in agencies like the FCC and the FDA, which are whose rulings are routinely challenged at the D.C. Circuit and elsewhere in the judiciary, versus agencies like the SEC and the FTC, which are more rarely challenged, less frequently.
The SEC.
Yeah, well, the SEC, there have been, some of the Chamber of Commerce attacks some of those have been great. Gibson's work, Gene Scalia's work on that. That's been good, and I think it's been very actually beneficial to the SEC, because I'm a believer that sort of aggressive challenge and robust judicial review that makes the agency better ultimately. And I think the SEC keeps trying, and they keep losing some of these, but I think little by little they're getting better on these. And you look at the FCC, and I think their rulemakings are at some level getting better. So I think that sort of judicial review is very important. And particularly on this, it's important that there be an atmosphere of non-retaliation to a company or to an entity that challenges the, you can understand why no one wants to challenge an SEC rule. They fear what the next step is going to be, what the next chapter is, what the next investigation is going to be. FTC, there's a similar scarcity of challenges to FTC rulemaking. So I think that's the effective judicial review is an important piece of this regulatory state as we think about technology. Finally, I just throw out, and I won't address it, but international harmonization. We operate essentially in every country except dictatorships. It's where we would love to operate there, but we are blocked by the countries in question. So we're forced to deal in the legal department and as a company with a myriad of rules, just an absolute patchwork of hundreds of countries' rules addressing the same general area, and that's a challenge that hinders innovation. That's a major check on innovation, I think, Peter. Anyway, those are just some practical observations, Larry.
Thank you.
Richard may have a question.
Well, so the next stage here, we'll like to see if you guys want to say. I have a million questions, which I will happily ask if you guys don't. But so let's let the panelists talk a little to each other for the moment. But start to think about what you might want to ask.
I mean,
there's microphones over there and there.
What I want to do is I want to make one comment or two about particularly what Mark said. I think the battle over the internet stuff is, in a short-term sense, it may well turn out to be relatively monopolistic, but if you let the technology go in the long term, it will become more competitive, and the dynamic element is what inclines me towards light-handled regulation. I want to pick up what Peter said. I thought this was a panel about technology in the high-tech industry, but I have had the misfortune of teaching both environmental law and the FDA law, and the level of public ignorance and disgrace in these statutes is simply too much. Pam said earlier on, with respect to Wickett and Philbin, just get over it. I can't get over it. That's what. And let me give you a specific story as to why I cannot. When the FDA was founded in 1906, it could not regulate the manufacture of drugs within the states. It only got that power in 1938. And Peter was talking about the level of progress, and I'm going to talk about insulin as one of these particular items. Insulin was a drug invented by a man who could only be described as a constrained lunatic, a man named Banting, who worked in Canada and eventually got the support of Eli Lilly, which was a great company at the time in doing this. This is the progress of this. He figured out basically in a nightmarish dream what to do. He was relegated to a basement laboratory. Every single production system that he made, he managed to screw up. He finally got the formula, then promptly forgot it. But nonetheless, from the time that he first got this idea to the time that insulin was on the market was a grand total of less than 3 years. First 10 people who took it, most of them died, some of them lived. By the time they got to 1930, it was in broad spread general use. Now, what's the game Peter was talking about? Well, let me mention what the treatment for diabetes was in 1921. It was slow starvation. Essentially, you slow down metabolic processes, you reduced a normal woman of 120 pounds to 50 pounds, and then she croaked. The woman who is most known for this was a woman named Elizabeth Hughes. She was the daughter of Charles Evans Hughes. She was down to 49 pounds at the age of 15. When they finally got insulin into her, literally it was like Lazarus rising from the dead. She lived to the age of 73. She started to gain weight. She married by 1930, had several children, and managed to self-administer. The FDA had only one role, or the government had only one role to play in this story, and that was when they tried to get pure ethanol in order to do the isolation. It was barred by prohibition, and it took the Rockefeller family to get some influence so as to allow them to do this, because the government regulators thought that methanol would do just as well as ethanol, and so why is it that you have to take something that's booze? Now, the basic position on dynamic production is as follows. That one invention, which took 3 years, contributed more to human beings and their welfare than every single advance with respect to diabetes in the 90 or so years that has followed. Those have all been very important, but they're an order of magnitude difference. What you have to do in technology is understand that the first generation of simple-minded truths gets you a huge gain, and the next things you 10 times as much and get 1/10 the amount. What the FDA has done is killed that cycle. And it has done so because of this notion that they somehow or other are going to protect people from the only things that will save them, and because they come with the view that unless you could prove to our satisfaction it's safe, individuals cannot make judgments. In fact, with here's where Justice Griffiths and I have a violent disagreement. I mean, he wrote this elegant opinion on Abigail's Alliance, which says people don't have a right to use a drug which passes a Phase 1 title. What the question was whether or not you can essentially wreck the FDA by giving it only the power to control trivial types of activities, after which the voluntary networks of private organizations, physicians, international work will give you 10 times as much information on an absolute updated basis, so forth. This is essentially, as far as I can see, one of the long-standing public disgraces which causes huge losses with respect to innovation, huge amounts of gratuitous suffering, requires companies to say absolutely nothing lest there be retaliation. That's what Ted referred to. And it's all the patient groups that have to go against all the professionals who know how to do quote-unquote science, most of whom are using techniques that are 60 years old and don't even understand what they're about. That's what's at stake in the larger issue about regulation. And unless we fix that thing up with the FDA and the EPA and all the drugs on chemicals and so forth, we are consigned essentially to long-term mediocrity. The rest of the world is a little better than we are on some of these issues, worse on others. But this is the central issue of our time, and we have so locked ourselves in, starting with Wickard and Filbert and carrying through with the sort of fiendish regulatory program in which everybody knows best for what individuals should do except the individuals themselves. I've just mentioned one thing. My late mother-in-law, she got myasthenia gravis. And this woman, by the time she figured out what it was, knew more about that disease than most of the physicians who treated her, and constantly gave her all the information going out. One of the things that you do when you stop this kind of information is all the Hayekian knowledge that comes from the accumulation of the spirits as a system going upward is killed in favor of a bunch of bureaucrats who only know how to read charts which they don't understand anyhow. This is what we have to fight about. That's why Wickard and Filbert is important. The individual mandate in the grand scheme of things is a piddly, unimportant, insignificant, stupid kind of regulation. What really matters is the long-term flow of technology, and that's what we're killing off. So to Pam, I can't forget about it. Thank you.
Yes, go ahead, because that's a direct response.
Yeah, so I mean, this ties into Peter's question, right? And Peter talked, I think, very persuasively about some of the problems we've had in innovation and what he called the what. The why story, which I think Richard picks up, Peter has sort of suggests, well, the problem is regulation, and Richard picks that up directly. It is not my brief here to defend the FDA. I actually think. I actually think that Richard may be right on this, although I will note that there are some, pretty compelling stories on the other side that got the FDA involved in this in the first place, right? So the trade-offs turn out to be hard, right? From an economic perspective, not to Richard.
No, they're not hard. Period.
I think there are circumstances in which decisions that individuals make have significant effects on other people in the world, whether it's vaccination questions, smallpox, or the like. There are circumstances in which we actually care about not just what individuals decide, but how those individual decisions affect everyone else. The broader question, though, abstracting from the FDA, in which I agree that the FDA has, in fact, made innovation in the drug industry much harder, and the broader question, I think, is how well we can map this slowdown across a range of formerly innovative sectors to regulatory sclerosis. And I'm not sure that mapping is necessarily there. I'm not saying it's not, but it's just some sort of things we want to know, right? One is, well, we do have a couple of substantial exceptions, and boy, they're big exceptions, right? I mean, it's a pretty bleak picture that Peter painted, but if you look at actually just the computer and internet world and the financial world, there's a heck of a lot of value and wealth created here that was unimaginable 40 years ago in communications, but also in terms of all the things that computer technology does in all of those other industries, right? We've had productivity gains in lots of industries that seem like they're not innovative industry, whether it's the steel industry or anything else, largely because we've had computer innovation in those industries. So we're innovating, and maybe we're innovating in other areas too. We've got seemingly interesting movements in robotics, seemingly interesting movements in nanomaterials. 10 years from now, maybe we'll look back at this and say, boy, that was the dawn of the space era, right? Something that we all have thought for most of my adult life has been dead, but now seems actually to be maybe waking up. I guess the sort of two other points I'll note on the kind of why question that give me some pause, make me want to think further about this. One is that the time frame that Peter identifies as kind of when innovation stopped is largely speaking the time frame not in which regulation started getting really heavy and the government started getting really involved in our lives. For the most part, it's been the opposite, right? It almost maps to the Reagan Revolution, to trying to back away from too much regulation. And while I don't think that that we have in fact significantly reduced the size of government in any meaningful way in those periods, it doesn't seem like there's a sort of linear relationship between amount of regulation and slowdown in these industries. And the final point, I guess, there to make is regulation is a national thing, but technology presumably isn't, right? And so one thing that's worth asking is, well, where are all the other countries that we might expect to be picking up the slack? Now, you can tell similar stories for some of those countries in Europe and whatnot. But, I remember in the mid-1980s when everybody in the country was absolutely convinced that, by 2000, we're all going to have to speak Japanese because Japan's going to be running, they're going to eat our lunch. They're driving technological change. U.S. is falling behind, and it's going to be a disaster. Now we say the same thing about China, and maybe that'll turn out to be true 20 years from now, but maybe it won't. If the story is a regulatory story, I think you've got to do a fair bit of puzzling about, why different countries with very different regulatory regimes don't seem to be innovating in places that we're not.
So let me give a few suggested answers to all the different questions you raised there. So in my mind, the basic dichotomy is world of bits versus world of stuff. Stuff was regulated by the EPA. I believe that was founded in 1971. 1970, close enough for government work. And so I think that would be the signal issue I would flag. I think the FDA became relentlessly more onerous as the decades passed, and I think the 70s were also a major inflection point with the FDA.
62.
I think that, and then I think, there's sort of all sorts of other areas we could point to where the load went up quite a bit at that time. I was not debating about tax policy, and in my opinion, we're at a point where marginal tax rates are not actually the most important thing. If you were to reduce tax rates marginally, that doesn't solve the problem that we need to construct hundreds of new nuclear reactors in this country very quickly. And I personally wouldn't mind having slightly higher taxes if I could actually have the freedom to spend the other money on things I'd like to spend it on. And so if we had, as it is, I'm living in a country where, for many purposes, the effective tax rate's 100%. I am not allowed to spend any of my money on innovative drugs. I'm not allowed to spend any of my money on supersonic private jets, and on down the line. Now, I would say, so I think there was a very important slowdown that took place around that time. You can map it onto a whole series of other things that shifted culturally. We shifted from science fiction as a literary genre has collapsed. Technology is described as things that are dangerous or that don't work. When was the last positive sci-fi movie that's not a Star Trek rerun? And I think that so I do think we need to take this issue very seriously. I think the measurement question of how we measure these things is very hard. I suggest an economic measure, and there has been a deceleration in wages. I think that the international question is very interesting. There are some good reasons to hope that we will head towards a more multipolar world, and maybe innovation will start picking up in other countries in decades to come. But the reality is that most of the world doesn't really need to innovate. The emerging markets are poor countries, and they can do well just by copying things that work. And that's basically what the developing world is doing. It is becoming developed. It is basically a convergence theory of globalization. If you're a talented person in China, you should open a McDonald's franchise or a Coke franchise or something like that. That's the easiest thing to do. The only place where people need to really innovate is in the developed world, which is Japan, Western Europe, US, all of which suffer from this very heavy regulatory load in one form or another. And so we're not really living in a world of hundreds of countries where people are free to do whatever they can. Parenthetically, I think the shift in the language from first world and third world, which was the way the dichotomy existed in the 60s, to developed and developing world, is another illustration of this tech slowdown. First world versus third world is agnostic on the question of globalization, but generally was positive on technological innovation. Developed and developing worlds is bullish on globalization and implicitly very bearish on technology, because the developed countries are those countries where, by definition, nothing new can happen. They're developed.
Investment, as was the internet, in fact, this entire semiconductor industry, and nuclear bombs too. There's a very substantial amount of government investment there, and you can say, well, it's become politicized, but the question is, okay, can you just depoliticize it, or do you just withdraw as the government entirely? And there's a distinction to be made, I think, personally, between investment versus regulation. It is possible to deregulate and still invest. It goes back to what I said before, which is you cultivate, you invest, but then you get out of the way. And so what I want to think about is whether the problem here is that we've spent so much money doing regulation badly that we've wasted all the money we might be able to use to invest sensibly, and for that matter, poisoned everybody's reaction to any government involvement whatsoever. Because I think if you spend too much time focusing on how bad regulation can be, which it very well can be and often is, and I think all the points that have been made here so far are exactly right, there are other roles for government to play in investment, and I think they tend to eclipse what I think is some potential for a positive role to be played by the government here, deregulation, but not de-investment.
Just before, I will let you go, but you guys should, if you have questions, now would be the time to start lining up. Thank you. Okay.
So I mean, one sentence on Tony's point. I am philosophically inclined to that view as well, that the government has positive things to do, although I will note in defense of Peter's position that the government expenditures in science and technology are by and large in the industries that we don't seem actually to be seeing substantial innovation, right? The government spends lots of money in medical, pharmaceutical, biotech, alternative energy, and so forth, not in software or internet research particularly.
That's because they have to offset all the difficulties on the regulatory side. What I think is correct, what Tony said, is the book that you should read is by Vannevar Bush in 1945 called Science, the Endless Frontier. And he basically got it right. And the one-sentence version of it was, we subsidize research up to the point of proof of principle, and after that we run it to the patent system. The government's repayment is a non-exclusive license of any technology that is used with government funds. Otherwise, do with it what you will. And that, I think, is what you have said. That's the way I best understand it. The question is how much of it comes private, how much of it public. What is interesting is on the bioscience side, the original grants were quite small. And what has happened since that time is that if you look at public investments now, they have all shifted from basic infrastructure, including science, to transfer payments, which is the other great thing which Peter did not mention. The switchover is just enormous, and most of the innovation programs on infrastructure are disguised transfer programs because you get labor protections and all the other stuff built into these things, making them totally corrupt. The damage that was done by the New Deal on structural issues we have yet to live down, and we've managed to manifest and multiply it in the years that have followed.
I want to just make one quick last point, if I might, on the question of whether government can do something positive on the technology and science area by investing. And it strikes me that that it depends a great deal on who is in the government to do that. And if you look at the 535 people in the U.S. House and Senate, I think by a generous count, about 35 of them have any sort of background in science or engineering, and the rest are sort of living in the Middle Ages. They don't understand that windmills don't work when the wind is not blowing, or that solar power does not work at night.
The sun doesn't shine.
Worse yet, they're proud of that.
And I think, and so I think that if you want to have a technocratic government, you have to have a government that has a lot fewer lawyers in it. As a basic first cut, and so I think we have sort of and we have sort of very interesting instance of this with the whole clean tech failure, the Solyndra failure specifically, where the legal question is just a process thing. It's the Republican critique is, there were all these process violations and kickbacks, and then the Obama defense is, well, it was a process that was followed to allocate the money, but the substantive question is, does the science actually work? And it seems like nobody has any competence to actually evaluate whether that works, and that's not a question that's sort of a question that's beneath or above or both people's dignity to think about. And so, as a libertarian, I have no problem with lawyers being in government. But if you are a liberal person who believes that government should be driving science, then you should have some powerful affirmative action quota for it being a government heavily dominated by scientists and technocrats.
So I'm just going to go back and forth. So, first question.
You may have people up top, too.
Yeah.
Oh, there are microphones up there.
Yeah, it's by,
Okay, so we're going to go, I see it. We're going to go around, but we'll start here.
Hi, I'm Sam Mirelli, president of the Santa Clara University chapter. I'm curious about seeing so many Silicon Valley firms supporting net neutrality, because it strikes me as the camel's nose under the tent. And I wonder about this because I can't understand a limiting principle if we say that the telcos are a monopoly, and so therefore we should prevent them from stopping people from getting on. Why shouldn't we say Facebook has become a de facto or a very important monopoly of access and how people communicate with each other? So maybe we should force people to get on there. How can we have a limiting principle to say, well, if net neutrality at the protocol but not at the application layer?
You can't, is the serious problem on this thing. What you have to do under these circumstances is to go back to the literature written by Harold Dempsey some 40 years ago called Why Regulate Public Utility. Now, what he says is if you look at these regulations from a static point of view, you will always over-regulate, and the static regulation will make it difficult for new firms to get in there, so you'll hurt the dynamic situation. The dominant theme of convergence is essentially when you reduce everything to 0 and 1s, the industry-specific separations are gone, and if these guys screw up, within a matter of weeks, they will become Life magazine, and everybody will chip away at their side, take this bits and pieces and so forth. Look, that's what happened. Let me give you the one example. When MCI basically decided to enter into business against the Bell statutory monopoly, what it did was created a dedicated line for the shipment of information from St. Louis to Chicago. These guys didn't need any of the network interconnectivity, and they wanted high levels of security. Once those guys were able to break off, then the subsidy system that was created under the old Bell network started to crack down. And the last thing you wanted to do is to say, oh, it's really important to make sure that we have these cross-subsidies, and so therefore what we have to do is to prevent this break-off from taking place, and that, of course, is one of the problems that you get with the medical mandate. The true damage, and this is just one sentence, is if you actually understand how the government defines competition in healthcare, the level of stupendous ignorance saying that it can only be on quality and price, but not on the introduction of new products, because otherwise we can't standardize it. That's the real long-term stuff on this thing. So we are facing genuine crisis.
There's a little bit of a history missing to Richard's MCI story here, though, and it's important for the net neutrality debate, right? So MCI did do exactly what Richard said. They created a dedicated line. Basically, you would make a local call in St. Louis. They would, to a special number, which was an MCI number, they would pass it to Chicago, and then they would make a local call in Chicago. AT&T found out about this, and so they started shutting down all of MCI's local numbers because they didn't like the competition. The way MCI actually managed to survive was that they ended up filing an antitrust lawsuit against AT&T.
Because there was a monopoly.
Because there was a monopoly.
Statutory monopoly.
The network neutrality question, I think, is this. So it is right to say it's hard conceptually to, if our justification is just this is a monopoly and therefore we should regulate it, it's hard to distinguish that from Google or Facebook or a number of other things. I think you need a conceptual justification that's a little bit more directed at difficulty of entry. Right, so if you're going to distinguish the two, it's got to be on the question of there's something structural about the telecommunications infrastructure and the network that people have created that makes it difficult for somebody to come in and enter if you're doing something inefficient. Now, Richard suggests, and I think increasingly he may turn out to be right, that was absolutely true 25 years ago. It's not true today. Right, that as we're moving towards a world that has more possible means of alternative communication, we have people who have less control over the network, and we need to worry less about it. I'm not persuaded we're there yet, in part because all of those possible means of communication depend on government licensure at one stage or another. I've got to get the spectrum from the government, or I've got to get the wire permission from the government, and so forth. But in a world in which we had 10 different ways my information, my phone call could go from me to you, I wouldn't be worried about network neutrality.
Go ahead. No.
I was just going to say, I think there's a lot to what you're saying, and I think there's less unanimity among Silicon Valley people on net neutrality than you might think, for precisely those reasons. Frankly, I think the industry got a little down the road into supporting net neutrality before thinking through some of the issues that you raise here that are seemingly pretty apparent. But I don't want I don't think you should take away the idea that Silicon Valley was allied behind net neutrality. There's plenty of divergent opinion and debate on that.
I think also there's not one version of what net neutrality means. There are many different ways to think about what it is and how you regulate it. So there's not necessarily agreement on that. Unfortunately, she's not here. We have a colleague actually at the law school, Barbara Van Schevek, who's written a really compelling book, especially for those of us who believe that all wisdom wasn't written 40 years ago, called, what is it, Internet Architecture and Innovation, which I would really recommend to you. It's just a different way to think through sort of intermediate positions to keep the net open for innovation that go a little beyond, actually really a correction to antitrust law is the normal way to see it.
The one empirical thought I have on the net neutrality question is that we've been having this debate about net neutrality for close to 15 years, and the innovation seems to have been actually pretty healthy. And so I think the case for net neutrality empirically seems much weaker to me today than it was 15 years ago.
We are in the best of all possible worlds in which we are just about to impose network neutrality regulation, but we never ever do. And because of that, people are afraid to exercise power they otherwise might.
Okay, so let's go up there.
So Mr. Thiel kind of
just to identify. It's fine. Identify.
Peter Kiros, University of Michigan. Mr. Thiel started to answer my question, but I'd like to hear the rest of the panel's opinion on this. Given that most lawyers, politicians, and judges don't have strong technical backgrounds, can they make good technological regulation? And if not, should we be encouraging scientists and engineers to enter politics, to go to become lawyers or serve on the bench?
We don't want scientists in Congress. They're lambs for the slaughter. And in fact, the single worst government administrator today, without question, is Stephen Chu, Nobel Prize winner in physics, total buffoon in energy regulation. I mean, what you need to do is to get people who actually know the sound principles of property, contracts, tort regulation, and so forth. And if you get a guy who's a technology whiz and he has not, as it were, like Peter, transformed himself, you can't do it. Peter is qualified to serve in Congress because he's actually been in business. And that also makes a huge difference. I don't want these guys around.
So Richard wants more lawyers in Congress.
No. I want people who understand what the business of government is about. I don't care what their labels are. What I care about is, do they know something? And start with the President of the United States, who was a colleague of mine for many years, and the basic skill set to dealing with these issues that man managed to accumulate in 14 years at the University of Chicago is summed in a single digit, 0.
Let me say something about the University of Chicago.
No.
We have well-trained Stanford law grads in government. Others want to say anything, or otherwise let's go over here.
My question's for Mr. Falzone. I appreciate your willingness to say regulation maybe should be toned down, but that maybe investment should be stepped up. But my problem is who is doing the investment. So the economist Frederick Bastiat said that a good or a bad economist looks at what is seen, and a good economist is always looking at what is unseen. And so you talk about, well, this investment, but the problem is that when government invests, it's not creating the wealth, it's having to steal the wealth from people who actually would otherwise create it in other places before then allocating it in the way in which government then wants to. So my question is, who should, and I guess this is just very broad, but what would you say in response to that critique, especially as it pertains to technology, where I feel like the fast pace of it, I would trust somebody like Mr. Thiel to allocate resources in a way that I wouldn't trust the government at its slow plodding pace to keep up with technological innovation?
Well, the answer is you got to trust both. Absolutely. My point is that you shouldn't leave it all to private markets, and you sure as heck shouldn't leave it all to the government. That would absolutely be a disaster. My point is that there are certain public good components of it that I think the government may play a important role in some instances. Now, as far as stealing anybody's money, we don't steal anybody's money to provide for national defense. There are things the government rightfully provides for us, and that's why we have a tax base. My only point is, is the answer to lots of bad regulation to throw up your hands and just deregulate everything? I think not. I think the point is that there may be some terrible, terrible instances of bad regulation that you need to fix, and deregulation is part of the story, but just because you're going to deregulate doesn't mean you shouldn't also invest in certain spots.
The right way to think about it seems to me, is this. Are research universities useful?
The answer is yes.
Yeah, right. I think the answer is yes. But that is a statement, basically, right? I mean, the research universities are doing research in substantial part because they're taking government money and using it to do basic research that a private company is not going to do because it's a 20-year payoff, if anything, down the line. Right? Now, there may be ways to do that without government funding. If you can find some other cross-subsidy, if alumni are generous enough to do it, if we're going to charge tuition high enough, though that's got its own costs. Should government be competing with private enterprise to fund research? No. Are there areas of science that I don't think that the market is going to generate research in to the level that we might actually benefit from? Yeah.
Well, can I make a comment? If you actually look at it, there's some real evidence on this, on how the National Institutes of Science work. The key to its success for the most part was that the small grants, which are highly competitive, were all peer-reviewed by people inside the profession. And it turned out, for the most part, those things actually work quite well. When you get to big science, you can't quite use that project, so you're going to have to figure out where you spend $3 billion on putting a reactor of one sort or another. The project works much worse under that circumstances, because at this time, it turns out it's the Texas delegation against the Illinois delegation as to who's going to be able to rent it. So what you need to do, in effect, is to get government guys stressing the emphasis on small sciences and doing it that way. On the university side, what you have to do, since this technology is too expensive, is to figure out how it is you could pool joint ventures. And to give you one example, the proton source, which runs in Chicago, essentially what they do is they have pods. And what they did is they financed this thing by having each of the universities pay for one of these pods or a fraction of the pod, so that you get private development inside the thing, what you put in your pods, and so that the system becomes a highway, and then the pods become the cars, and you don't allow the government to decide what you put in the pod, but you now have joint financing to create the public good. You can get this thing done. You don't have to be a complete cynic about government support. You got to read the Vannevar Bush book. I mean, this was the guy who organized the science effort in World War II. He was no slouch. He was the guy who got the Los Alamos labs up. He got the RAD labs up in Cambridge. They knew what they were doing, and there's no reason we can't learn from them today.
Good evening. My name is James Bailey Brislin, and I'm a 3L in the evening division at Western New England University in Springfield, Massachusetts. My question this evening is for Mr. Thiel and Mr. Ouliette. Specifically, Mr. Thiel enunciated a very interesting dichotomy. On the one hand, the world of high finance and high technology, in which you have very light government regulation and great results, and then the world of stuff, in which you have heavy regulation and poor results. how do you fit the world that works, neither stuff nor technology, into that theory? Do you consider it to be highly regulated or lightly regulated? And how would you change the regulatory schema to make it better, more productive, et cetera?
Well, I would be in favor of going back to, say, a 1950s, 60s level of regulation in the world of stuff. I think even if you were in favor of government doing things, there are many cases where the government regulations are stopping the government from being able to do things it would like to do. I had a conversation a few years ago with some of the people in the Obama administration on why the stimulus bill, why couldn't they build any infrastructure? And it was, there were no shovel-ready projects you could actually build because it had all been regulated. They wanted to build clean tech windmills north of Chicago. You weren't allowed to build the power lines connecting the windmills to Chicago, so no windmills could be built. The high-speed rail in California cannot possibly be built because you have all sorts of local zoning rules that prevent it. So I think that it is really important for us to understand that that there is sort of no regulation, and there's light regulation, and there's moderate and heavy and insane and self-destructive, and we're somewhere between insane and self-destructive in many of these things on the spectrum. And we don't need to ask all the pure libertarian questions about, what about, should we have privatize the nuclear weapons program, and should we privatize, what about private roads? And, you can sort of, we don't need to deal with those problems. Go back to the 50s.
Yeah, no, I mean, okay.
Yeah, I'd say, I don't know that I have much to add to what Peter said, but I would say that the world of bits is certainly, less regulated than some of the other worlds, more regulated than it's not unregulated. There's plenty of regulation. That's I think an increasing problem.
And there is something about the world of bits where we have to realize that it's a cautionary tale. We had these geese laying all these golden eggs in technology, and the geese have all been killed, and the only one left is the computer goose. We killed the finance goose was killed last few years with Dodd-Frank. So the only one left at this point is the computer one. Yes. So I think unnecessary excessive regulation of computers is extraordinarily dangerous because it's the only thing that's left. Everything else has already been killed off.
Can I make a comment? I think Peter's wrong about one thing, and I'll try to explain why it doesn't challenge but strengthens his thesis. Environmental regulation is to some extent different from all the others because what you're concerned with are things that, when done, were private law nuisance that were actionable in 1200. I could say whatever you want to think about the halcyon levels of innovation in 1950, smog in San Marino was not one of the things that you praised. The big problem with the Environmental Protection Act and the Clean Air Act was not that it chose to regulate, but you have to go down a level and figure out what this proper scheme of regulation is. And you can't answer that question by saying I'm pro or against. Let me just tell you one of the huge blunders that they all made, which was they thought that they would grandfather old technology and they would regulate new technology. This is the fundamentally most expensive word in the Environmental Protection Act on air pollution is the word new. What this did, although nobody thought about it, is it completely disrupted the transmission cycles from old to new transitions. The regulations on the new stuff were intolerable, so the biggest area of litigation under the statute was what counts as a modification that allows you to keep over. This has gone on now for 40 years in which you put all sorts of rattle trap on old plants because you don't allow the new stuff to come in under the same thing. What you needed was a system of regulation that replicated common law rules in which damages which were caused by externalities, i.e. pollution of the real type, I don't mean carbon dioxide here, was basically punished because it was external. It didn't matter whether you did it through a new or an old plant. And if you had just done that system, you would have been able to stop 95% of these problems with a tiny fraction of the current cost. So that what happens is, it's one thing to say, and Peter's right clearly, ramp it down an order of magnitude. But when you actually do regulations, there's no substitute for knowing what's going on inside an industry, particularly in those cases where some regulation is indeed needed. And that's where the other piece of information has gone wrong. The system design for environmental protection regulation on every area you care to talk about is fatally flawed in the way in which they put this together. The political stuff on transitions turned out not to be a 2-year issue, but a 40-year issue.
Hi, my name is Chris Geyer from the University of Pennsylvania. This question builds a little bit on the last one. Going to the the two industries which Mr. Thiel discussed, the computers and the finance. A lack of regulation in the financial industry in the face of inadequate regulation exposed us to systematic risk and required strong governmental intervention. What are the major risks and or costs from a lack of regulation regarding technology? Is it limited simply to restrictions on innovation, or are there broader risks? And then following up on that, going to Professor Lemley's point about sort of a rule-based regulatory system, and given the slight mismatch in speed between which legislation is passed and technology develops, how can legislation be developed that is flexible enough to address some of the issues we've talked about and others that will arise in the future?
So I think this is a very hard problem, and as Richard suggested in his answer to the last question, right? It's a hard problem any time you've got to intervene, and you can't avoid intervening at some level. To me, by and large, and I think this is in line with what Richard is saying. We're just agreeing all the time.
Well, you're
kind of
agreeing with
alarming.
me, but
Yeah, right.
I disagree with you on vaccines, so that's a different.
It seems to me, right, for the reasons you suggest, right, we are generally speaking better served with common law and flexible rules than detailed legislative set parameters, right, in part because Congress can get them wrong. Because they don't understand, or Congress can get them wrong because they have a vested interest in doing particular things that might not be efficient, and in part because they just don't change. Right? So, I think so. For example, in the patent system, I've argued, along with Dan Burke, right, the way we need to account for the very different characteristics of the pharmaceutical and the biotechnology industries and the information technology industries is not by passing legislation that's specifically tailored to each of them, but it's by having general rules that the courts can actually apply with some sensitivity to the needs of different circumstances.
The key illustration on that is on injunctive relief. The common law rule with respect to massively dislocating injunctions was to delay innovation, imposition. And so if you have this mosaic in the business you're in and there's a thing that's patented, we give you 6 months where you pay a royalty, and by that time you design around it and all is well, instead of having an instantaneous shutting the thing down. And that's a classic illustration where you do that for him, but you don't do it for a guy who wants to infringe on Lipitor, for example. So Mark is, yes, Mark, you're exactly right.
On your first question, so it seems to me we're starting to see, I think that there are two mechanisms by which we start to regulate the computer internet industry. One is Hollywood, right, which has a very powerful lobbying machine that is pushing very hard to try to restrict the freedom of the internet precisely because they view that as a real danger point to them, because a lot of the stuff that crosses the internet is piracy. That did not go away with the defeat of SOPA and PIPA. It will be back, and that's one flashpoint. The other one, which I think people pay less attention to, and in some sense is a harder problem because you got to worry about it at some level, is cybersecurity. Right? The real nightmare story for computer regulation is some seriously destructive infrastructural attack on the internet that takes out some critical, whether it's the airline network or the electric grid or something of that nature. And that would not only be catastrophic in its own right. I think at that point, the idea that computers are largely an unregulated area goes away. Got it down here.
Hello, my name is Henry Nickel. I'm from California Southern Law School. Just a quick question. A number of you have touched upon this issue of the global marketplace, and I was wondering if you could comment on the creeping danger of harmonizing with foreign law. and expanding federal regulation. I speak specifically of recent controversies that relate to European demands that the U.S. adopt a data privacy regime similar to what exists in Europe. What is this a danger? What is the magnitude? And how can we reconcile these types of demands from foreign governments that we expand our regulatory regime?
I got a couple thoughts about that one, because I think when you talk about harmonization, what you actually see is not so much harmonization, but ratcheting up. It's a one-way ratchet again and again and again. So especially in the copyright sphere, when you see the move from the United States and its domestic copyright policy that existed for a couple hundred years, and you move into the Berne Convention and TRIPS, what you see again and again on the international level are so-called minimum standards of protection. So every country has to provide at least this much, but is free to regulate more and more and more. And so the imbalance that occurs there is you protect more and more, but what you leave out are the safety valves that are designed to make sure that the regulations don't go so far as to kill the golden goose. In copyright, that's creativity and expression. The idea is, yes, you create copyrights and you give certain limited rights, but you have a whole bunch of safety valves like fair use and things like that that let other people use the material to do new things. And so if you ratchet up the protection constantly and you leave behind those protections that are supposed to protect critically important public speech rights, then harmonization is really just, it's a recipe for eroding the basic balance that we've worked for a couple hundred years to construct.
This is Wickard and Filburn again. Well, because what they did is by having harmonization, they allowed the Department of Agriculture to nationalize production and to create cartels. That's what that case was about. That's what the labor cases were about. And what happens in the European Union, which Peter did not mention, is that the wrecking of the labor markets by harmonization, which essentially presents competition, has created 30 and 40% unemployment rates in various places. Because once you get when you have the common market, it's open, subject to Brussels, which is a big plus, but then you get the protective barrier so as to keep everybody else out. And that's essentially what's happened in the American agricultural market. We have a common market inside the United States subject to cartel regulation. The reason it's more disastrous in labor than it is elsewhere is because in labor the productivity goes down, whereas the technological improvements in agriculture until we got on this war against GMOs and other kinds of things was large enough so that it more than offset the monopoly losses. But American labor, you go right back to those 37 decisions. National cartels are very efficient, and harmonization becomes a synonym for basically for cartelization, because the guys who are running these programs are all committed progressives and social democrats.
But look, on the internet in particular, the problem is it doesn't obey national boundaries, right? So, you know, I mean, general harmonization on good ideas is usually a good thing. Harmonization on bad ideas is usually a bad thing. But autarky doesn't work on the internet because your bits aren't obeying those boundaries, right? And so the worry, my worry is that the alternative to some level of more or less rational harmonization is the equivalent on the opposite side of what Tony's talking about, right, which is the most restrictive regulatory regime ends up controlling, right?
Yes, I pretty much agree with, I have to say, I agree with that in the sense that, and I don't, although I don't like international governments, international bodies. On the other hand, you know, if you are an internet business, you are confronted with just a nightmarish set of complex local rules, and you know, there's sort of state by state rules in certain areas of the U.S. When we ran PayPal, we had to find ways to comply with money regulator rules in all 50 states, and that was probably harder than if you had a single one. So I think it's a complicated question about what's more efficient in different cases.
Yeah, by the way, this also comes up with standard-setting organizations. And what happens is there's now another report, I think it's by the FTC, announcing private market failure, so they want to basically get more government included in setting these things. I actually wrote with Scott Keefe and Dan Spolver a report for Qualcomm, was on the other side of it, and I'll just mention to you one fact, which is that these organizations, all of them, are in hundreds of different standard-setting organizations, and that the number of breakdowns when you do it is very small. And there, what we've heard about, Ollie had said about the about the antitrust laws, the one very good set of antitrust rules are essentially who can join a particular group, and essentially what you do is you allow complements but not substitutes to come together, because that allows you to overcome the double marginalization problem without creating the cartelization problem. So that's a classic illustration where they did it right in the 1990s and they're about to do it wrong in the next decade if the new FTC report takes over.
I was going to say a practical observation on some of the one-way ratchet issue and ever-increasing scope, but the danger of harmonization. I think technology can help push back against that. For example, as Peter alludes, we have, since we operate we have users in so many different countries with many. They do not embrace an American vision of free speech. They do not have a First Amendment. So even, we're not just talking about Pakistan, but countries like France and Germany and others will, famously, since the Yahoo days, since the early Yahoo days, 2001, 2002, on Nazi content, for example, the rules were established then that yes, even though you serve this from the United States, this is, if it's viewable in France, you're supporting that, that's a violation. But the technological fix, we've avoided that one-way ratchet by things like IP blocking. So now we block by IP address. So if there's content that is posted in Sweden that's illegal in Pakistan, we can block that to Pakistani users without letting Pakistan impose its vision of speech.
Yeah, so you've got separability, right?
It's separability, yeah.
The key.
Again, just to underscore, so there's, as with net neutrality, there are many versions of harmonization. Conflict of laws is a harmonization principle that doesn't require substantive harmonization, and it's the choosing among them. There are problems that can be solved with conflicts rules and problems that require substantive harmonization, and the hard part is figuring out which one you want to do. I will say it's different than the national government, though, because the ability to get substantive harmonization at the international level is a qualitatively different issue.
Absolutely.
Hi, I'm Dan Lazar. I'm a law student at the University of Florida. My question is primarily directed at Mr. Thiel and Professor Lemley, but others can feel free to answer. With technology essentially being the last area without significantly broad regulation, in light of the failure or the current failure and controversies surrounding SOPA and PIPA and other proposed bills regulating the technology area, how do you feel that the technology sector will ultimately be regulated, either through government, through market forces, or through a combination of the two?
I have an answer.
All right, go, Richard.
Let's let Mark, the people who are asked to answer, have a say, maybe.
This may be our last chance to disagree. So
okay, all right, I'll try to disagree with you. I think the greatest protection that technology has against regulation is the pace of innovation. That is, the more that you can constantly change and morph your product, the more difficult it is for people from the outside to take it over. It's when a technology becomes stable, like electricity and like telephones and so forth, that you can start having very impressive national rate regulation systems such as those that developed between 1880 and 1940. I don't think you'll ever be able to get that in the technology business. So I think, in effect, so long as you innovate, you're relatively safe. If you slow down and they start to regulate, you'll never be able to speed up again.
Yes, I just, sort of the one elaboration on that is my intuition is that the future is, it's very sensitive to initial conditions. So if you can sort of imagine a model where there's an escape velocity from politics and you get the positive feedback loop goes quickly enough, the technology outpaces the political system, and we continue to see acceleration, and that's what's happened thus far in the computer area. Or you can imagine a case where the political system sort of dampens down things, and then of course you end up with monopoly-like industries, and then you have arguments that are like utilities and they should be regulated more heavily, and that's what I submit has happened everywhere else. And so because you have this positive feedback loop between technology and politics, whichever one goes faster will dominate, and you can imagine radically different equilibria in the future. And we can imagine a world that's completely static, or we can have one where you have progress starts to reaccelerate, and the computers sort of take over everything. That's sort of the optimistic case. There's one goose left, but it's powerful enough to overrun everything else. But that's the question.
And so it comes back, I think, to where I started, which is the idea of the Mother May I regime, right? So the real question is, do I have to seek forgiveness or do I have to seek permission? right? In a regulatory world in which I have to seek permission, if I can't build until the government says yes, if I can't do X or Y, you're not going to outrun it. Technology is not going to outrun politics in that world. In a world in which I can build it and we can do a bunch of things, then if I can run fast enough that the world starts to see the benefits, it turns out to be harder and harder to regulate those benefits away. And we've seen that again and again in copyright and new media technology, where if I can get my technology up to scale fast enough, the copyright owners who want to shut it down won't be able to. Right? TiVo makes it big enough, fast enough that even though the copyright owners really, really wanted not to be able to shut down TiVo because it allows you to skip commercials and successfully sued a smaller company that hadn't scaled fast enough, they can't sue TiVo today. Right? They're not. You know, it's implausible as a matter of regulation. Right? So yeah.
What you do is you embed the commercial in the show, so as to avoid the fact that you can go through. That's the adaptive response.
Or you make your commercials better.
Well, but the Super Bowl, people prefer it, yes.
Last question.
I'm Meredith Ponder. I'm a law student from Georgetown, and one of the things that some of my friends and I have been considering during this whole internet piracy debate has been the increasing globalization of media, and in particular movies and television shows that have different distribution dates in different countries. And so this question, I think, is for the panel at large. I know that I have friends who, for example, downloaded Downton Abbey, for example, that was shown in the UK 3 months earlier than it was released here. And there are programs that won't ever be released here from other countries. How can corporations work on that? How can regulations work on that? Which is more effective, the marketplace? I mean, that's something. I mean, if personally, if distribution is simplified, you know, that we would be more than willing to pay to do these things.
And I think this is critically important, right? So if Hollywood's goal on the internet is make sure it doesn't interfere with our 8-tiered distribution model in which it can only go to Hulu between week 5 and month 3, and then it's got to come back off, and it's got to be in Redbox only 28 days thereafter, that's all going away. And it should go away, right? This is arbitrage via the internet, and it's a good thing. And, you know, there's a piracy problem out there, and you know, we need to think about intelligently how to solve that problem. But the way to solve that problem, I think, is not a bunch of new laws. We've got a bunch of copyright laws already, right? Adding SOPA and PIPA is not the way to solve that problem. The way to what Hollywood needs is not a new law. What Hollywood needs is a business model that takes advantage of the digital world. And you know, the music industry is starting to get there, right? They spent a dozen years ago, their goal was stop the digital transition, no music in digital format. They fought and lost that battle for a while, and then they started to kind of figure out ways to make money in this digital world, in part because we allow lots of people to have lots more access to things they never would have seen because they were only released in the UK. The video industry is not there yet, in part because for them the piracy problem is more recent as bandwidth has increased, but that's where they've got to go.
Look, I have a slight disagreement with this. I don't think we ought to tell firms that if they have an efficient business business model, forget it because we can't enforce as a first order. There's a deep problem in the law of torts which carries over to this. The private right of action against the admitted wrongdoer is very difficult to enforce. So what you want to do is to get another action against somebody which is always overbroad. So that, for example, you're in an apartment house and somebody molests you, you can't find the victim, you sue the apartment house owner for that. That's the problem you do it, and the trade-offs are horrendously difficult. And so what happens is what Mark suggests is when you see the writing on the wall, after a while you give up on the law and you go to self-help. And the point is we'd rather have as little of that shift as possible without having the overprotection, and that's a very hard problem to solve.
Just one quick point. If Hollywood really were satisfied with private enforcement, that would be one thing. But the move you're seeing now is, yes, Hollywood wants the government and the taxpayers to pay the price for that enforcement. And that's especially ironic when the windowing is actually helping drive the piracy problem, because if firms are not responding to demand by giving users what they want at a price they're willing to pay, a fair price, then the piracy is only going to get worse because you can't get it legally.
Yeah, but the complication with all of this stuff is that what they're saying is private enforcement is broken down. We need public enforcement. This is the same argument people made in favor of consumer protection laws. We get all these guys doing something wrong, they commit fraud, we can't stop them. And so it's not just enough to say that these characters are completely wrong. You have to be much more specific in trying to figure out the overbreadth and the underbreadth on these particular kinds of mechanisms. And my objection to these statutes as acronyms I always forget is that it seems to me that the industry is not aware of the fact that there are other things on the other side of this, so they always overclaim and then they get themselves wildly discredited.
They're aware now.
What?
They're aware now.
Well, they better be. I mean, they...
Okay, and with that, I will, as we close, I'll just tell you a quick story. I went to Chicago. I taught there at the beginning of my career, and one of the things I learned, and the other Chicagoans, Ted and Michael and Lee out there, can probably all confirm this. If you're dealing with Richard, what you do is you go to him with any question that you have, and then you get sort of the Epstein version of the universe with respect to it. And then when he finishes, you kind of go, yeah, but, and then he'll spend the next 15 minutes explaining all the arguments on the other side, and then walk away thinking you're really smart to have thought of all those arguments. That's true. I've done that on multiple occasions. So thank you very much. Thanks to the panelists for a great panel, and thank you for coming.
I think the vaccine problem is simple.